Good afternoon, Miss Grace.
Hey, Judge.
Hey, how are you?
Good morning.
Muted.
Good.
Hey, Judge.
I know. Who said good morning? Good afternoon.
Me.
It's probably morning for some of us.
I've been at this since about 8 o'clock, so yeah.
I can imagine. Right. And I see Miss Kimball, I've got you. Thank you for putting all of that on your name tag. I appreciate that.
Good afternoon, Your Honor. Thank you.
Yeah, we're trying to get the rest of the world to do that, but you go, oh, I
Hey,
can't.
Judge Missy.
Hello, good afternoon.
Hey, Judge.
Yes, ma'am.
I can't hear her.
Nope, you can't hear me. Let me make sure my volume is up. Let's see.
I can hear you, Judge.
You can.
Sorry, Judge. I hear you now.
All right, good. Hasn't been raining that much today, so maybe we won't have too many technical difficulties. Thank you, Ms. Harrison.
Judge, the reset date is 9/1.
9/1.
Yes, ma'am.
I'm in the right courtroom.
All right, we're ready to start.
Yes, we're ready, Judge.
All right, let me give my opening. All right, good afternoon, ladies and gentlemen. I'm Judge Regina Mincy, and this is the Fulton County State Court Expedited Accusations calendar. This is the calendar for cases in which individuals have recently been arrested and charged with certain misdemeanor offenses. Soon after the arrest, the Fulton County Solicitor General's office has already accused these cases of the offenses brought against them, and the case has been bound over to the Fulton County State Court. Nevertheless, this will usually be the defendant's initial appearance before state court judge. We're able to address bond, arraignment, and possible plea offers if one has been made by the state at this juncture. I think everyone has already heard that the SAP reset date is September the 1st. I'm going to begin and advise everyone that this whole entire proceeding is being recorded as well as live streamed on YouTube. I want the defendants on this calendar to know you have certain constitutional rights, one being that you have a right to an attorney to represent you at this juncture. Most of you already know who your attorney is, whether it is the PD's office or a private attorney, and I know that they are here. Also, I want to remind the defendants that you do have a right to remain silent. Anything that you state about the facts, the circumstances, or anything that occurred with your case, remember that it, number one, is being recorded. Number two, the state is here. So please defer and listen to your attorneys, and try not to make any statements that may be against your interest. Your attorneys will direct you on that. This is really not your time to talk, honestly. All right, we'll get started. Who do we have first, Deputy?
Position number 2.
This is case number 22 CR 005566G. Curtis, is it Bethea?
Yes, ma'am. Yes, Your Honor.
All right, and this, you're being charged with one count of battery The offense date is August the 17th, 2022. You have anything pretrial?
30 cycles, last arrest, October of 2020 for probation violation for a non-fingerprintable charge in Fulton County. Record does indicate the defendant is currently on probation for aggravated assault, 16 SC 142024. Sentenced October of 2017, 4 years confinement, 6 years probation. Record indicates 6 violations of probation, 2 failure to appear within the past 10 years, a 2015 misdemeanor battery conviction. Nothing further to add.
All right, thank you. And is this ASG Guidry?
Yes, Your Honor, it's my case.
Yeah, good afternoon.
Good afternoon,
All right.
Your Honor. We are recommending a $2,000 surety bond. No further contact with Jinwo, that's JINWO, Cho, CHO. No alcohol, drugs, or weapons, and a 1-day anger awareness. We would like to note that he currently has no bond set. This incident occurred on August 17th of 2022 at 10th Peachtree Place, MARTA Station. Officers received a BOLO on August 19th about the defendant, who is known as Midtown Puncher. The defendant struck the victim with a closed fist in the eye as Mr. Cho was running towards the Georgia Tech trolley. That punch caused a swollen eye and bruising. This incident was caught on surveillance camera, and the defendant was seen wearing the same outfit that he had on August 2nd, on August 19th. Your Honor, we're asking for that surety due to the defendant's criminal history. As they have stated, he is on probation for aggravated assault, and he also has some arrests with no dispositions. Those are a simple assault from 2015, an aggravated battery from 2016, and he also has a criminal damage from 2020, and I do not know if that is resolved or not. So we are asking for the stated recommendation.
All right. Mr. Is it Mr. Silverman or Mr. McLean? Which one?
No, yes, ma'am. Larry Silverman for the defendant in this case. Mr. Bethea, 38 years old, has lived in Atlanta, I believe, most of his life. However, he does not have any family in the area. Yes, he is on a probation hold. He's currently residentially challenged, as we say. Would ask for a signature bond because he's being held on a probation violation, I believe, and he'd like to be able to deal with that. But I think that's DeKalb County, so he can't deal with that until we can bond down on this offense. And he would not be able to post a $2,000. I'm sorry, did the state ask for a surety bond or signature bond?
Surety.
Surety bond. He doesn't have anybody who can post the surety bond for him, so we'll ask for a signature bond so he can be on his way to DeKalb. That's all. Thank you.
Okay. I'm going to order the $2,000 surety bond. I'm going to order no further contact with Jinwo Cho. No drugs, alcohol, or weapons while on bond. And I didn't hear stay away. Did I stay?
No, Your Honor. I mean, this is his first incident at MARTA, but I don't see a reason to restrict him. I mean, he's known as the Midtown Puncher, so a puncher could have been anywhere, so no stay away.
Okay. All right, that will be it for my ruling for now. Anything else, counsel?
Nothing further from the state.
Nothing from the defense. Thank you.
All right, thank you.
Position number 6 is next, please.
Okay. All right, this is 22 CR 005570D, Essence Drone. You're charged with 1 count of DUI, less safe, 2nd count of driving improper erratic lane change, a 3rd count of failure to report striking a fixed object, all with the offense date of August 19th, 2022. Pretrial.
No prior history, Judge. She does meet the criteria for UJR pretrial. Nothing further.
All right. Ms. Guidry.
Yes, Your Honor, we are recommending a $3,000 surety bond for the DUI less safe, a $500 surety bond for the improper erratic lane change, and a $500 surety bond on the failure to report striking a fixed object, with the condition that she have no alcohol, drugs, or weapons. Your Honor, this incident occurred on August 19th of 2022. Officers were informed by a citizen who saw a vehicle with a pop tire driving and striking the median on West Crossville. Officers searched the area when he witnessed a street sign ran over at the intersection of West Crossville and Crabapple Road, and he also noticed a headlight on the ground. Another officer saw a trail of marks consistent with a rim of the road. They followed that trail and they found a Camry with significant front end damage and a passenger headlight missing. The defendant got out of the vehicle. Officers observed her to have watery and glassy eyes, and they could smell the strong odor of alcohol. She also tripped over her feet and constantly swayed. Upon asking if she had anything to drink, she stated that she had drank a Four Loko 30 minutes prior to this. Officers found a crushed Four Loko can in her cup holder at the time. The defendant refused implied consent and failed sobriety. Your Honor, given the safety for the community, that she continued to drive, hit objects, and was in the road when they found her, we would be asking for that surety bond, although she has no history.
All right, Attorney Kimball.
Yes, Your Honor, thank you. Ms. Drone currently lives with her father and her stepmom in the city of Roswell. She's resided there for the past 3 years. She is also currently a student at Georgia State University, and she is in the nursing program. As Ms. Harrison did state, she has no prior criminal history, no arrests, no interactions with law enforcement. We would actually ask the court to consider a signature bond on all 3 charges, but if the court was not inclined to do so, we would ask the court to consider a $1,000 bond on the DUI and the signature bond on the remaining 2 underlying charges.
What year is she in school?
I will allow Ms. Drone to answer that question for the court.
Junior year, 3rd year, 1 more year left of nursing school.
Are you full-time?
Yes. Your Honor.
All right, I will go ahead and allow a signature bond through pretrial in the amount of $4,000. That will be $3,000 on the DUI, $500 on improper lane change, and $500 on failure to report striking a fixed object. That will be a total of $4,000. I'm going to order, obviously, no drugs, alcohol, or weapons while on bond. And sometimes I restrict the driving, but I'll refer to that as long as you have a valid driver's license with DDS. Yes, you can drive. If you don't, then you shouldn't. And I think that will be it. Anything else, counsel, that I need to take up?
Nothing further from the state.
No, Your Honor, thank you.
All right, thank you.
Your Honor, may
Position
I be
number-
excused? I'm sorry.
Yes, you may, Ms. Kimball.
Thank you, Judge.
All right, thank you.
Position number 8 is next, please.
'22 CR 005573E. Ardrana Fuller, you're charged with 1 count of battery family violence. The offense date is March the 16th, 2022. Pretrial.
No prior history, Judge. Does meet the criteria for UJR pretrial. Nothing further.
All right. Ms. Gidry.
Yes, Your Honor. She currently has no bond set. We are recommending a $3,000 surety bond. No further contact with Lee Williams Jr., common spelling, 1-day anger awareness, third-party contact with a child, and no alcohol, drugs, or weapons. Your Honor, this incident occurred on March 16th of 2022 at 3571 Collier Drive, Northwest Atlanta. The victim advised that he was trying to pick up his daughter to drop her off at school when an argument ensued with the defendant. The defendant started throwing rocks at his car window. And then as he was trying to get out of his car, the defendant rushed him, striking him several times in the face with a closed fist, causing lacerations to his face. Again, at that time, the parties did have a child, so that's why she's charged with battery family violence. Your Honor, we were not able to speak with the victim in this case, and we were concerned for his safety, so that's why we're asking for the stated recommendations, although she has no history.
Larry Silverman for the defendant. Your Honor, this actually appears to be a situation where Mr. Williams may have been the aggressor. There was a conflict between them, and according to the defendant, Mr. Williams actually tried to hit her with his car. Mr. Williams has a long and violent criminal history. If Your Honor were to check the court docket, he's actually under Lee Williams with 2 different dates of birth, and there's quite a number of aggravated assault cases, which supports the theory that he may have been the aggressor in the case. Ms. Fuller has no criminal history, as we've heard. This is her first offense. She lives with her grandmother and siblings at a good address in Atlanta, and in light of the facts of the case and her criminal history, would ask for a signature on bond, no more than $1,000.
Did I hear whether or not she's working or employed?
I work.
Excuse me, let your attorney answer.
Okay, Ms. Fuller, you can go ahead and answer that question, just that question, please.
I'm employed.
Okay, what do you do?
I'm a prep cook.
Prep cook. Where do you work?
Hospitals.
Okay, and how long have you been in that job?
4 years.
All right, nothing further, Your Honor. Thank you.
Thank you. And did I hear, did the state ask for third-party contact with visitation with the child?
Yes, Your Honor. We're in agreement with third-party contact with the child.
Your Honor, the defendant has full legal and physical custody of the child, so we don't believe a third-party visitation is necessary for her. The child lives with her.
And Your Honor, we're only asking for that due to in the facts, it states that the victim picks up the child every morning to bring her to school. So if that's the case, then third-party contact is necessary. Oh, wait, you're saying that she has, I'm sorry, she has custody.
She has custody, but
She has full custody.
She has full custody, child lives with her. Yes.
Okay.
and does the victim come to pick up the child for school every day? That would be my next question.
No, he does not.
He does not?
Occasionally, picks up the child occasionally. He does not on a regular basis.
Okay. And the child is how old?
Yeah, I don't have that information, but the defendant may be able to answer that.
Defendant, Ms. Fuller, how old is your child?
1.
1 year old?
I have her here. She'll be 2 in October.
Okay.
And you're right. I don't know if you looked up the alleged victim, but he's listed in the court system with 2 dates of birth, 11/27/80 and 11/27/81. It's got multiple convictions for ag assault under both dates of birth.
And just to reiterate, it could be his father because he is a junior, and I have not been able to look up that information, but he is a junior. So
Well, I don't normally make a habit of looking up the criminal records on my victims. Just going by the minimal facts that I have at this point, I will go ahead and give a signature bond through pretrial in the amount of $4,000. I'm going to order that Ms. Fuller stay away from this address, this Colony Drive, whose address is that?
Your Honor, I believe that's her address.
That is her
Okay.
address.
All right, so there will be no stay away. And I apologize for that, no stay away, but I will order no further contact with Mr. Lee Williams Jr. And as far as any visitation that may occur, it must obviously occur with a third party. Since you are to have no contact with Mr. Williams, Ms. Fuller, then therefore, if there is any allowed visitation, it must be precipitated by a third party, not yourself, since you cannot have any contact with him. Is that understood?
Yes, ma'am.
All right, no drugs, alcohol, or weapons while on bond, except for anything prescribed to you. And I'm gonna also order the one-day anger awareness course at through pretrial. Anything else, counsel?
Nothing further from the state.
All right, that will conclude this case.
Well, Your Honor, I just would like to ask that there be no further violent contact. I'm concerned about the logistics of the Mr. Williams coming to see the child when Ms. Fuller actually has full legal and physical custody of the child. And at this point, I don't even know if its paternity has been determined, but it would be within her legal right at this point to deny visitation. And I'm concerned that Mr. Williams is going to come to the house. She may say, I don't want you to see the child. And then there's going to be a violation of the bond terms.
If he comes, well, she does have the authority to deny visitation. And if she does, which, you know, until there's a cooling off, well, it looks like this happened back in March. But if she doesn't want him there, then she can call the police to say he's not to be here. I didn't invite him here. You know, I'm on bond. We're to have no further contact. He came to my house, but don't open the door. Don't let him in. Protect yourself. And just let someone let him know that you don't want to interact with him. You can't, and you don't want him to have visitation. If he doesn't have an order for it and anything like that, then I guess you can always deny it and go from there.
Okay, Ms. Fuller, do you understand what the judge just said?
Yes.
Okay,
All right, thank you.
thank you.
All right, who do we have next, deputy?
Position number 13, please.
Okay. '22 CR 005561B, Nicole Osborne, charged with 1 count of battery, offense date August 19, 2022, pretrial.
6 cycles, last arrest, August of 2007 for probation violation. Underlying charge is battery, 2 counts. That was a no disposition listed in that arrest. Record indicates a 2006 simple battery conviction, misdemeanor. Nothing further to add.
All right, ASG Waldrop.
Good afternoon, Judge. How are you?
Good afternoon.
Thank you. Your Honor, with respect to this particular case and the state's recommendation on bond, the state is requesting a bond in the amount of $3,000 straight or surety on the charge of battery. We're asking that the defendant have no further contact with the victim in the case, Aggentrice Greer, and that is AGGENTRICE, Greer, GRIER, that she stay away from the location of 3155 Hickman Place, have no weapons or firearms on or about her person while out on bond, and no drugs or alcohol, in addition to taking the one-day anger management. And Your Honor, this case and this charge stems essentially from an incident that occurred when the defendant went to the address of the victim in the case and began aggressively banging on the door. When the victim came to the door and opened the door, the defendant immediately barged in and began assaulting him, striking him multiple times. And additionally, other individuals that she was with also came into the residence and struck him. This resulted in a knot, a visible knot on his head. And as you heard, she has 6 previous cycles. I show a 2006 conviction for simple battery already, and that is the basis for the state's recommendation in the case.
All right, thank you. Mr. Silverman?
That's mine, Your Honor.
Oh, I'm sorry.
Thank you. Your Honor, 2006 was, I believe, 16 years ago, and I don't know when the date of occurrence was, so we would ask the court to discount that heavily. This is her sister's boyfriend. She says she is not responsible for that. She did not put a knot on his head, so she denies the allegations. She works at Security. It's called Security CSC Atlanta. She's done that for quite some time now. She is quite willing to stay away from this person and any location that the court orders. This should be a signature bond in our opinion.
She's how old?
44. Sorry, Miss Osborne, 44.
Gotcha. All right. I'm going to order a $3,000 surety bond. I'm going to order that there be no further contact with the victim, Mr. Greer. No drugs, alcohol, or weapons. Stay away from 3155. Is it Hickman Place in Atlanta?
Hickman, yes.
No drugs, alcohol, or weapons while on bond, except for those prescribed to her. And I won't do the 1-day anger awareness at this point. But I don't know, is there anything else, counsel, I need to take up?
Not from the state judge.
All right,
Nothing else.
thank you, Mr. McLean. That will conclude this case.
Position number 14 is next.
All right, this is 22 CR 005560C, Jasmine Owens. You're charged with 1 count of false report of a crime, offense date 8/19/2022, pretrial.
Second arrest, first arrest was September of 2012 for crossing state county guard lines with weapons and toxic drugs without consent and possession of Schedule 1 or 2 controlled substance with intent to distribute in Tannell County, Georgia. She was offered first offenders on the crossing the guard lines, and that was sealed. She was convicted on the possession of Schedule 1 or 2 controlled substance. Nothing further. She does meet the criteria for UJR pretrial.
All right. ASG Waldrop.
Yes, Judge, thank you. This particular charge stems from an accident that actually occurred on August 19th of 2022 when 2 individuals, males driving the defendant's vehicle, got into an accident, and upon getting into that accident, then left the scene. As the car was being towed and removed from the road, the defendant showed up and essentially told the officer that she had been driving the car when it had gone into the intersection and had been struck by another vehicle. And that forms the basis of the false report. With respect to bond in the case, Judge, the state is requesting a $1,000 surety bond that the defendant have no drugs or alcohol while out on bond and no weapons or firearms on or about her person.
All right. Mr. Is it McLean?
Right. Your Honor, Miss Owens' 2012 Tattnall County matter was quite some time ago. We would ask the court to consider a signature bond in that this is 1 count. It is false information, and it is the nature of the crime that she's alleged to have occurred, to have done here. We would ask the court to consider a signature bond. She is stable and has the same address, 178 Maury Avenue. And she is aware of the seriousness of it.
Working. Do you know if she's working, Mr. McLean?
Oh, I don't have a job down for her. Miss Owens, did you have your work history?
No,
Unemployed?
not currently.
Okay.
Not currently, right? Okay.
All right, I'm going to order a $2,000 signature bond through pretrial. Gonna order no drugs, alcohol, or weapons while on bond. And I believe that's all I need to take up. Anything else, counsel?
Nothing.
Okay.
Position number 17, I'm sorry.
That's okay.
Hey, we in court, I'm sorry.
Okay. All right, this is 22 CR 005557D. Is it Madeline or Madeline Rendon? Is it Miss Rendon?
I think it's just Madeline.
Okay. All right. You're charged with 1 count of DUI less safe, a 2nd count of improper passing of emergency towing or highway vehicle, and a 3rd count of failure to yield right of way to emergency vehicle. The offense date is August the 19th, 2022. Pretrial?
No prior history. She doesn't meet the criteria for signature bond through pretrial.
All right. ASG Waldron?
Yes, Judge. With respect to just a short factual basis, Officer Christensen with the Roswell Police Department was actually in the process of making a stop and was standing on the side of the road where his vehicle's blue lights were active and flashing. They were plainly visible. As he had this other driver stopped, he observed a vehicle nearly strike his patrol car and nearly strike his person. That vehicle did not slow down and did not give adequate space when passing. He then conducted a traffic stop on that vehicle in which the defendant was identified as the driver. He noticed the odor of alcohol, asked her to perform field sobriety evaluations, and those evaluations indicated impairment to the officer. Ultimately, she was arrested. Given the facts and circumstances of the arrest, the state's recommendation in terms of bond on the DUI count is a $3,000 straight bond, on the improper passing, a $500 straight bond, and on the failure to yield, a $500 straight bond, for a total of $4,000 straight or surety bond. We are asking that the defendant have no drugs or alcohol while out on bond, that she not be able to drive unless with a valid license, and that she complete a risk reduction course.
All right. Mr. McLean?
Your Honor, awareness courses are appropriate perhaps, but a substantive course, while it might be up to her, probably should not be ordered by the court because it tends to imply guilt. She is innocent until proven guilty. It is her first arrest. We would ask the court to give her a signature bond. She works as a receptionist at a place that's referred to as Tony's Beauty Brows. So it's eyebrows, I suppose. So she's worked there as a receptionist for a while. Her address is stable. It's the same address that is on the booking screen. So we'd ask the court to consider a signature bond.
All right. I'm going to order the $4,000 signature bond through pretrial. That's $3,000 on the DUI, $500 on the improper passing, and $500 on the failure to yield, for a total of $4,000. No drugs, alcohol, or weapons while on bond, except for any prescriptions that are prescribed. No driving unless you have a valid license from DDS. And I think that will be it for the ruling. All right, thank you.
Position number 11, please. Not you.
All right, this is 22 CR 005565H, Devonte Jenkins. You're charged at 1 count of simple battery family violence. The offense date is August the 18th, 2022. Pre-trial.
1 moment.
Okay.
Yes.
Second arrest. First arrest was January of 2021 for burglary in the first degree and theft by take-in. That was by, it appears to be Criminal Investigation Division, the DOC. No disposition listed in that arrest. GCIC does indicate a hold out of Reedsville, Georgia, for failure to appear for that arrest. Nothing further.
All right. ASG Waldrop.
Yes, Judge, just for a brief factual basis, this charge stems from an incident in which the defendant actually slapped the victim, Miss Jariah Childs, in the face after an argument about him coming home late. She did indicate to the officer that at the time that she was pregnant, and that he did, in fact, grab her throat as well, although that did not result in a loss of consciousness. With respect to a bond, the state's recommendation is a $3,000 surety or straight bond. We are asking that the defendant have no further contact with Jariah Childs, that he stay away from the incident location of 176 Stratford Drive, have no drugs or alcohol while out on bond, and no weapons or firearms, and complete 1-day anger management.
All right. Ms. McLeod?
Yes, Your Honor. My client is 19 years old. He is currently employed, although he tells me he has not quite graduated from high school. He had education up to the 12th grade. He and the alleged victim, Miss Childs, they live together and they share a 1-year-old child. They also have another child on the way. I had the opportunity to speak with Miss Childs earlier, and she tells me that she does want to have contact with my client. She tells me that when she called the police, she didn't expect it to go where it is. They were just both a little bit upset, and she was arguing with him, and she denies that he struck her, Your Honor. I would ask the court, given the circumstances, not to order no further contact between them, because they do share a child, and also they have another child on the way. As I said, the victim does want to have contact. I would ask a signature bond for my client, given the fact that he's never been convicted of any crimes. He's presumed innocent regarding any earlier arrests that he may have had. If he would be given a signature bond, Your Honor, with conditions of no further violent contact with Ms. Giles, I think that is what she wants and what my client will want, Your Honor. We do not oppose the 1-day anger awareness. Thank you.
All right.
And Your Honor, if I may just very briefly address the statement that she, I guess now is denying having been slapped. I do want to point out that on scene, the victim did show the officer a video of the defendant slapping her. So there is that.
All right. I'm going to order the $3,000 surety bond. I'm going to order a stay away from the 176 Stratford Drive. You make bond, Mr. Jenkins. I think there needs to be some more cooling down. This just happened on yesterday, day before.
3 days ago,
3 days ago. I'm going to order stay away from the 176 Stratford Drive. I'm going to order no further contact with the victim, Jariah Childs, right now. If your attorney wants to seek a bond modification later, we can do that. And no drugs, alcohol, or weapons while on bond. And that will be the ruling of the court.
Thank you, Your Honor, that concludes my business before the court today. May I be excused?
Yes, you may. Have a good weekend.
Thank you, Judge. You too.
All right.
Position number 7, please.
Okay. This is case number 22 CR 005572F. Amal Duhart. You charge it 1 count of simple battery, 2nd count of giving false information to law enforcement officer. The offense date is August the 18th, 2022. Pretrial.
25 cycles, last arrest May of this year for probation violation. And USM, it's Arlington, Washington. It appears to be military.
No.
Record indicates the defendant is currently on U.S. probation for unlawful transport of firearm. Sentenced July of this year with 24 months and 42 days of probation. I am showing a hold from USM in Arlington, Washington, 1 violation of probation within the past 10 years and a 2006 simple battery misdemeanor conviction, nothing further.
All right, Deirdre.
Yes, Your Honor. We are recommending a $1,000 surety for the simple battery. For the giving false information, we are recommending a $500 surety with the conditions that he have no further contact with Shapara, that's CHARPARA, Gildersleeve, GILDERSLEEVE, a stay away from 235 Peachtree Street, Northeast Atlanta, and no alcohol, drugs, or weapons. Your Honor, this incident occurred yesterday at the located address. The victim advised that the defendant was causing a disturbance at her store. She asked him to leave. The defendant then shoved her in the chest. This incident was caught on video. Officers began to canvass the area to find the defendant. And when they found the defendant informed him that his name was Tony Walker with the birth date of 7/20/1974. They fingerprinted the defendant using a scanner, and his real name and birth date was determined through the scanner. Your Honor, we are asking for those recommendations due to his criminal history and having 25 cycles.
All right.
All right, thank you, Your Honor. This is my case.
Okay.
Sorry, are you ready for me?
Yes.
Okay, Larry Silverman for the defendant. This incident occurred at the CVS store based on the address. I think it's the one on Peachtree Street at the Hub Shopping Center. Mr. Duhart is on felony probation, and there's a hold from the U.S. Marshals. I assume they will be here to pick him up pretty quickly, given the nature of the offenses, and by that I mean the relative severity or lack of severity. I'd ask the court to just give him a signature bond. He's not going anywhere. He's going to have to come back. And I think that in this situation, a signature bond is adequate to assure his return. Again, he does have some greater problems with federal probation that he would like to be able to tend to right away. So that's all I have.
Age of employment.
I don't have that. I don't believe he's employed at the time. Mr. Duhart, are you employed?
Not at the time of when I don't.
Okay, thank you. And I also indicated to the court he does not have prior felony convictions in the last 10 years, does not have a history of failure to appear within the last 10 years, and does not have a history of probation violations within the last 10 years.
All right, I'm going to order the $1,500 surety bond, 1,000 on the simple battery, 500 on the false information. No drugs, alcohol, or weapons while on bond. Stay away from the CVS store on Peachtree. I think is it 225?
It is 235.
235. Stay away from that CVS if you get out on bond, Mr. Duhart. No drugs, alcohol, or weapons while on bond, except for anything prescribed to you. That should be, that's the ruling of the court unless counsel has anything else to take up.
Your Honor, what about a no further contact with the victim?
Oh, I'm sorry, yes. And no further contact with the victim, Shapara Gildersleeve. And that should be the ruling of the court.
That's all, Your Honor.
Nothing further from the defense.
Okay.
Position 10, please.
Okay. This is 22 CR 005562Y. Altamore Harrison, you're charged with 1 count of simple battery family violence, 2nd count of cruel to children in 3rd degree, both with the offense date of May the 8th, 2022. Pre-trial.
Third arrest. Last arrest was June of 2021 for aggravated assault in Fulton County. That is an open case, 21 SC 179105. Record indicates a 2013 misdemeanor DUI. Nothing further.
All right. ASG Waldrop. Okay.
Yes,
Okay.
thank you, Judge. Just clarification, Your Honor, I did NOD the charge of cruelty to children in the 3rd. That obviously cannot be substantiated based on the simple battery charge. So I did go in and NOD that. I'm not sure why it's showing up on the calendar.
Okay.
But I will fix that
Okay.
in Odyssey. With respect to bond, Your Honor, state's recommendation on bond is a $5,000 surety bond on the count of simple battery family violence. We are asking that the defendant have no further contact with the victim in the case, Bailey Smith, that he stay away from the incident location, and that is at 7554 Springbox Drive. That he have no drugs or alcohol and no weapons on or about his person while out on bond. Your Honor, these charges or this charge rather stems from an incident in which the defendant was invited over to Miss Smith's residence for a meal. He was upset that the meal was not ready when he arrived because she had fallen asleep. They then got into an argument in which he grabbed her multiple times. There is an allegation that he did choke Miss Smith. And so, Your Honor, based on that, the state does anticipate possibly transferring this case to the DA's office, but we are pending a strangulation assessment to determine whether or not that particular act rises to the level of a felony. So again, with respect to the bond, we're asking for the $5,000 straight bond. This is based on the defendant's prior history. As you heard, he has an ag assault arrest. I believe that is currently on judicial hold in Superior Court due to the unavailability of the defendant. I believe with him now being in jail, they'll be able to go forward on that particular case. From what I could see in Odyssey, it appeared to be on judicial hold, and that order is in Odyssey as well. So that would be what the state would be requesting.
Okay.
Larry Silverman for defense. Your Honor, some background on Mr. Harrison. For the previous 7 years, Mr. Harrison was employed with Hope Atlanta, a homeless outreach nonprofit. He has left that job and he is scheduled to start a truck driving job on Tuesday. Now, I'd like to point the court's attention to the arrest affidavit, and it appears that we may have a self-defense situation here. While there apparently was some type of dispute between the parties, the arrest report indicates that the victim, Bailey Smith, ran to the bedroom upstairs or ran upstairs to retrieve her handgun, which Mr. Harrison described as a 9mm Glock. She told the police officer that when she went to retrieve her handgun, there were no rounds in the magazine, stating she only wanted to scare him off. And then apparently the dispute may have continued somewhat, and she told the officers she ran back upstairs to load her handgun, but Mr. Harrison had left the location. So I think what we have here is probably a case of serious self-defense or serious mutual combat, which would not, I believe, wouldn't warrant a bond as high as the state is seeking. One thing I would like the court to consider is that Mr. Harrison resides with his mother. That was confirmed to pretrial services by his sister, and his mother has suffered a stroke and suffers from congestive heart failure, and Mr. Harrison lives with her and is her primary caregiver. Nothing further.
And Your Honor, if I may, just in response to the assertion of potential self-defense, the only defense was on the part of Ms. Smith in this case. She did indicate to the officer that she went to retrieve her handgun, but there were no rounds in it. But she only did that after the defendant grabbed her shoulders and she broke free for a second time. So he grabbed her shoulder, she broke free, told him to keep his hands off of her. He then grabbed her again, she broke free again, and then only then ran upstairs to retrieve the handgun, which again had no rounds and was not loaded. And she did indicate to the officer that that was the case and that she only wanted to scare him off. So I just wanted to make that clear, Judge. And he was asked multiple times to leave the residence.
Thank you. All right, I'm going to order the $5,000 surety bond on the simple battery family violence. And that will be a $5,000 surety bond. No further contact with the victim, Bailey Smith. A stay away from the 7554 Springbox Drive. No drugs, alcohol, or weapons while on bond. And I think that will conclude the ruling of the court. Anything else, counsel?
Your Honor, what was the address again, please, for the stay away?
7554 Springbox Drive.
Thank you.
All right.
Nothing further from the defense.
All right, that will conclude this case.
Position number 16, please.
With 22 CR 005559D. Devonte Pledger, you're charged with 1 count of willful obstruction of a law enforcement officer, 2nd count of pedestrian in the roadway, both with the offense date of August 19th, 2022. Pretrial.
Your Honor, GCIC indicates no adult history on file. He does meet the criteria for UJR pretrial. If granted a release, he will require an adult cosigner. Nothing further.
All right, thank you. ASG Walden.
Yes, Your Honor. With respect to the state's recommendation on bond on the obstruction, the state is requesting a $1,000 bond, and on the pedestrian and roadway, a $500 bond. We are asking that the defendant have no drugs or alcohol while out on bond, and no weapons on or about his person. I do show that this is, while only the third arrest for the defendant, his prior arrests involved weapons charges, possessions of either firearm or knife while in the commission, as well as a previous hijacking of a motor vehicle. And so, Your Honor, I understand the charges of obstruction and pedestrian and roadway don't necessarily appear to be so serious, but the state is concerned given the prior history, and we request a straight or surety bond in this case.
All right. Mr. Silverman or McLean, which one?
McLean.
Okay, sorry.
Your Honor, did his mom make it on there? Is that iPhone?
Anyone on for Mr. Pledger for that case? Any witnesses or victims in the Pledger case?
Yes, mother.
Okay, you're the mother
Okay.
of the defendant?
Right, marked as iPhone, Your Honor, is Latondra
Mother.
Pledger. And she's at latondra.pledger@yahoo. Your Honor, he is a high school student. I did ask him if he had any adult arrests. His delinquency period, did involve a couple of arrests there. They're serious, but still, at the tender age of 17, he is getting better here. Just this particular arrest, there was an allegation that disturbed me the most that I discussed with him about who he hangs around and how it looks for him to hang around the wrong people. I believe that was a fruitful conversation. We would ask the court to hear from the mom. Mom, do you think that if he were allowed a signature bond, would he be able to handle it and stay out of trouble?
Yes.
Okay. The court may have further questions for you on that.
Mhm.
Your Honor, his ambition upon graduating high school next year, I believe he's a senior. So he intends to go to trade school and continue to learn more about mechanics because he's already learned quite a bit. And he does work for Bulldog Movers, even though he's a student in high school.
He enrolled in high school?
I understand he is a student there. Mr. Pledger, Devonte, are you, up until this arrest, were you going to class on a regular basis?
Yes.
We can't hear you.
Yes.
Okay.
You're enrolled in high school. You're in the 11th or 12th grade?
I'm in 12th grade.
Were you going to school this summer or did your school start this week? What high school are you in?
I started school this week.
You need to speak up.
I started school this week.
Okay, you did?
Yes.
Okay. And Mom, are you prepared to co-sign on a bond if he gets a signature bond?
Yes.
Okay. And he lives with you, is that correct?
Yes, live with me and his grandparents and his little brother.
Okay. All right, I'm going to order a $2,000 signature bond through pretrial. That'll be $1,000 on each charge. No drugs, alcohol, or weapons while on bond. I'm gonna also order that you attend school and try to make sure you're on track to graduate. And Mom, I think you have to bring a ID and utility bill to the jail and when bonding him out and co-sign.
Okay, can I use it come on the email? Is that fine?
It's fine, but your name has to match the bill and the driver's license.
Okay, one more question. it's not in my name, it's in my mother's name.
Oh, because you're
It's
residing there
grandmother.
with your mother.
Yes, ma'am.
What do you say to that, Ms. Harrison?
You don't have any bills in your name that matches your driver's license?
No, I only have a phone bill, but it don't come in the mail or nothing. It just comes to me, like on the phone.
You can take a printed email bill and it can be printed out, but everything, the point is, it all has to match.
Is all have to match.
Yes.
I have to be the one to sign it.
If you're the co-signer, yes, your information has to match the residence where he will be residing.
With a bank, with a letter from the bank work.
Stating what?
A letter from the bank. With
Well,
my
when are you
name.
gonna get that? Monday?
I got one now. A letter from the bank with my name on it.
Coming to that address?
Yes, ma'am.
Not a utility bill. What is the letter? Are you talking about a bank statement?
No, it's stating that what it'll take because I had overdraft. And it's stating how much it'll take.
Ms. Harrison, that's your call.
No, Judge, we need a utility bill.
You need a utility bill?
Can your mother co-sign for him, his grandmother?
Yes, she can.
Is she able to make it down to the jail to do that?
Yes, when today?
You can go today.
And it's the jail by the downtown, by the Greyhound?
No, it's the 901.
It's on Rice Street. It's
901
Rice Street.
Okay.
It's about a mile northwest of Georgia Tech.
One moment. Who will be
Okay.
the co-signer, Judge?
Right, we need the name of who's gonna be the co-signer. If it's not going to be you, then we need his grandmother's name because that needs to be written in as to who will be bonding him out.
Okay, can you give me a second, please?
Got to check with them.
Okay, you're going to ask her, I assume?
Yes, ma'am.
Okay.
You got a phone number? Put it in there too.
An address.
You know address too? Oh. All right, then just hit enter.
Is this the grandmother's information? Helena?
Yes.
What is her name? I'm sorry?
Helena.
Helena?
E. Pleasure, same last name.
How old is she?
$55.
55, okay.
55, yes.
All right, so we have her name and I think I see it in the chat. All right, so she's okay with doing that and she will bring one of the utility bills to the home and everything will match with her ID?
Yes.
All right, counsel, is there anything else need to take up? Mr. Pledger, your grandmother is gonna co-sign on your bond, so please govern yourself accordingly and go to school.
Position number 1, please.
We done?
Larry Silverman for the
Done, you all, yes. So you may sign off, Ms. Pledger, and then have your mother
Okay.
to get to the jail, okay?
Okay.
All right, thank you.
Thank
Uh-huh.
you. Yeah.
All right, I'm sorry, Deputy, which position again?
Position number 1, please.
Okay, I had it there and I wasn't sure. This is 22 CR 005563J. Dwayne Armour, you're charged with 1 count of theft by taking and 2nd count of giving false information to a law enforcement officer, both with the offense date of August 19, 2022. Pretrial?
35 cycles. Last arrest, June of 2021 for probation violation. Underlying charge is unknown. That was in DeKalb County. Record does indicate the defendant is currently on probation in DeKalb for aggravated assault. Case 17 CR 1932, sentenced November of 2017, 3 years confinement, 7 years probation. Record indicates 4 violations of probation and 1 failure to appear within the past 10 years. 2015 felony conviction for theft by taking, entering auto, and possession of tools. Nothing further to add.
Larry Silverman for the defendant. Mr.
Your Honor, may I give my?
I'm sorry, Mr. Silverman, the state hasn't gone.
Oh, I'm sorry. I thought I was listening to the state.
That was pretrial, that's okay. Ms. Idri, go ahead.
Yes, Your Honor. We're recommending for the theft by taking $1,000 surety bond, for the giving false information a $500 surety bond for a total of $1,500. No alcohol, drugs, or weapons, and no further contact with Lawrence Sloan. We're not asking for a stay away because it was at a Burger King. Your Honor, this incident occurred yesterday on August 19th. The victim advised that he gave the defendant his phone to use, and when he turned around to retrieve it, the defendant was gone. He eventually found the defendant at a Citgo. He asked for his phone, and the defendant told him, "If you want your phone, come take it." He called 911, and upon 911 arriving, they found the phone in his pocket, in the front pocket. Officers arrived and asked him what his name was, and he said that his name was Christopher Jones. We are asking for the stated recommendation due to the defendant's criminal history, as pretrial has stated, he is on probation for aggravated assault out of DeKalb County. He also has numerous convictions, and we are concerned for the safety of the community.
All right, now, Mr. Silverman.
Now it's my turn. Okay, thank you. Mr. Armour resides in Decatur with his father, so he has a stable base in the community. The incident, upon reading the affidavit for arrest, it appears to be something of a dispute. Doesn't appear to reflect on any of the behavior in this incident doesn't appear to be connected in any way with his prior criminal history. So therefore, the history is not indicative. I don't believe is indicative of his likelihood to reoffend. I don't recall, I did not hear pretrial whether he has whether he has failure to appears. I think he does not.
He does have a failure to appear.
He does?
Yes.
Okay, I'm sorry, I didn't see it in the initial report. I'd ask for a nominal bond of $1,000 for the entire case.
All right, I'm going to order a $1,500 surety bond. It's $1,000 on the theft by taking, $500 on the false information, for a total of $1,500 surety bond. No drugs, alcohol, or weapons on bond, while on bond. No further contact with the victim, Lawrence Sloan. And I believe that will be the ruling of the court unless counsel has anything else.
Nothing further from the state.
Nothing from the defense.
All right, thank you.
Come on. Sir. Position number 3 is next, please.
This is 22 CR 005567E. James Crooks, you're charged at 1 count of battery. Offense date August the 18th, 2022. Pretrial.
20 cycles with history in Georgia, Missouri, and Texas. Last arrest August of 2021. Driving while license suspended or revoked in College Park. No disposition listed on that arrest. Record does indicate a 2019 misdemeanor conviction for DUI in Gwinnett County, 2016 battery, family violence in Clayton County, and a 2016 felony conviction for terroristic threats and act and criminal trespass in Clayton County. Nothing further to add.
All right, Gidry.
Yes, Your Honor. We're recommending a $8,000 surety bond. He currently has a $3,000 surety bond. No further contact with Mark Williams, first name spelled M-A-R-C, Williams common spelling. No alcohol, drugs, or weapons. 1 day anger awareness and a stay away from 2195 Monroe Drive in Atlanta. That is a Chevron. Your Honor, based off reading the warrant has stated that it's very minimal. It states that the victim was hit in the head with a toy gun. However, we have received the incident report, and the incident report states that the victim or the defendant believed that the victim had stolen his keys to his car. The defendant then begins to chase the victim until the victim can no longer run. When he can no longer run, the defendant then begins to fight him. The defendant then pulls out a weapon, a gun, shoots at him, and then he hits him in the back of the head with the weapon, causing bleeding. The victim also sustained lacerations to the back, top, and lower half of his head from being hit with the weapon. The defendant did admit to striking the victim in the back of the head, but he states that the weapon was a plastic gun. No gun was found at the time. Still transfer this case as an aggravated assault, although the warrant only states that it's a plastic gun. Your Honor, given his criminal history, that he does have that battery, family violence, and terroristic threats conviction, given the nature of this crime and that now we do have more facts, we are asking for the $8,000 surety bond, given that we will transfer this case.
All right, Mr. Silverman.
Thank you, Your Honor. This is certainly a bizarre story. Mr. Crooks tells me that he gave the victim a ride. They stopped at the gas station to get some gas and also, I guess, some snacks. Mr. Crooks actually said he gave the victim, alleged victim, $10, told him to pay for $7 of gas and then get some drinks for both of them. While the defendant was out of the car, the victim took his cell phone and some valuables that were in the car and tried to lure Mr. Crooks away from the car. So it sounds like he was trying to set up a carjacking. Mr. Crooks asked the Chevron, the clerk in the Chevron, to call the police. The victim walked away with the keys and the phone, did not return for approximately 3 hours. When he came back and the police were called, he apparently repeatedly changed his story to deflect from the police that he was actually the instigator of this incident. There were 2 other people with the victim, so it appears that this was going to be 3 people who were apparently trying to set up this defendant for a robbery. I'm concerned about what the state is saying about, well, first there was a statement that there was a shooting, but then also that was a plastic toy gun. So in the arrest report, it just simply says plastic toy gun. There's no talk about any shooting. And if there was, it sounds like the shooting, well, it's plastic toy gun. Mr. Crooks is a college graduate. He is engaged. He and his fiance have a baby on the way. He works regularly for Uber Eats. He works a security job. He's developing a music career. And based on the foregoing, his ties to the community as well as the facts as described in the arrest warrant, I do not believe that the state's recommendation or request for the amount of the bond is appropriate. I'd ask the court to set it at signature bond of no more than $1,000.
And Your Honor, just to clarify, it stated that the defendant did admit to hitting the victim in the back of the head, but he stated that it was with a toy gun.
And give me the bond recommendations again.
A $8,000 surety bond, no further contact with Mark Williams, no alcohol, drugs, or weapons, 1 day anger, and a stay away from Chevron, located at 2195 Monroe Drive, Atlanta. And again, this bond amount is minimal, given that the defendant was shooting at the victim, and he also hit him in the head, causing bleeding and multiple lacerations.
And Your Honor, defense would object to the stay away. The location, the site really has nothing to do with the case other than the fact that's where it happened. But it was not an attack or any incident involving the Chevron. They were just there getting gas.
All right, I'm going to order a $5,000 surety bond. I'm going to order no further contact with Mark Williams. I'm going to order no drugs, alcohol, or weapons while on bond. And I'll order a stay away from the Chevron at 2195 Monroe Drive in Atlanta. And I think that will be it from the court.
That's all, Your Honor.
That's all, nothing further from the defense.
Thank you.
Position number five, but position number 4 is gonna be reset for MH, please.
Okay. Number 5 is 22 CR 005568G. Daniel Dean, you're charged at 1 count of battery family violence. The offense date is January the 6th, 2021. Pre-trial.
10 cycles. Last arrest was May of 2003 for possession of marijuana. That was a conviction. Also, he appeared in first appearance today under case 22 CP 211620 for possession of controlled substance schedule 1 or 2 with intent to distribute. And he received a $13,000 good bond. Nothing further.
All right. Idri?
Yes, Your Honor, we're recommending for battery family violence a $3,500 surety bond. Okay, no further contact with Jen Woe. I'm sorry, L'Oreal Jackson, common spelling, 1 day anger awareness, and no alcohol, drugs, or weapons. Your Honor, this incident occurred on January 6th of 2021 at 623 Griffin Street in Atlanta. The victim advised that the defendant was moving out when he became upset with her and punched her in the mouth several times, causing a laceration to her top lip. At the time, the parties did live together, and they had been living together for 4 months. The defendant does lack a violent history. However, we have not been able to talk to the victim. So for the safety of her and her concerns, we are asking for the $3,500 surety bond. Oh, and a stay away. I believe that's her address.
Okay. All right, Mr. Silverman.
Your Honor, the defendant resides in Atlanta he's separated from the victim. He lives with his sister in Atlanta and will live there after his release. It's very important that he get out of jail on a reasonable bond because he has a job. He has been a cook and cashier at a Church's Chicken on Bankhead Highway for 10 years. He's cook, cashier, and does a little bit of everything there. And he is concerned that he could lose his job if he doesn't get out of jail. There's no objection to a stay away from the victim's home. There's no objection to no further violent contact or no further contact as the court deems appropriate. And I would just ask for a lower bond, and in the alternative, a signature bond, so Mr. Dean can get back to work. That's all. Thank you.
And do we know at all from either counsel, what's the relationship between the victim and the defendant?
Your Honor, they were dating it. As defense counsel has stated, they are no longer together. However, we have not had contact with her. And the defendant was moving out at the time as well. And there's no indication that they have children together.
All right.
No, they do not have children together.
Okay. All right, I'm going to order the $3,500 signature bond through pretrial. I'm going to order no further contact with, is it Marielle Jackson? Stay away from 623 Griffin Street in Atlanta. No drugs, alcohol, or weapons while on bond. All right, clear about those conditions, Mr. Dean?
Yes.
All right,
Judge, did you say 35 or 25?
35.
Thank you.
Mhm.
Position number 9 is named.
This is 22 CR 005571C. Tristan, I'm not sure how to pronounce your last name.
Garbage.
Garbage, okay. Charged with 1 count of public drunk, a 2nd count of disorderly conduct. The offense date is August 19th, 2022. Pre-trial.
Six cycles with history in North Carolina, Illinois, Tennessee, and Washington. Last arrest was September of 2020 for making false or misleading statements. In Washington, no disposition listed on that arrest. Record does indicate a 2018 misdemeanor conviction for intoxication and a 2020 misdemeanor conviction for domestic violence in Illinois. Record also indicates there's a hold in Charleston, Illinois. Nothing further, Judge.
All right, ASG Guidry.
Yes, Your Honor, this incident occurred yesterday at 202 South Main Street in Alpharetta, that is in Fulton County. Officers responded to an impaired person at 210 South Main Street, and they found the defendant at 202 South Main Street, which is the State Farm building. He was behind that building urinating on a trailer. Upon placing him in the vehicle for an arrest after he had admitted to being intoxicated, he started to refuse officers' command and started to ball up his fists, making threats to box the officers. And then after placing him in the vehicle, he attempted to break the window by kicking it and headbutting the window. He was then placed in another vehicle, and then he began to resist again. Although these facts are kind of minimal, it's public drunk and disorderly conduct, so we are recommending a $1,000 signature bond for the public drunk, and for the disorderly conduct, a $500 signature bond, and no alcohol, drugs, or weapons.
All right.
Larry Silverman for the defendant. Your Honor, defendant doesn't disagree with anything the solicitor has stated. $1,500, was it $1,500 recommendation, Ms. Guidry?
Yes, $1,500 signature.
The defendant believes a $1,500 signature bond is appropriate and would ask the court to enter that, order that I'm sorry, order that as such.
Okay. All right, I'm going to order the $1,500 signature bond through the jail. No drugs, alcohol, or weapons while on bond, Mr. Garbage. And the stay away from, is the address 202 South Main Street in Alpharetta?
He was at one address and it seems as if he started walking to the other one. I don't know if the building's connected or not, or if it's just down the street.
Oh, he started at
210
and ended up at 202 or vice versa?
Vice versa. He was at 202 when they received the call and he ended up at 210.
Okay, and we know the 210 is a office building where State Farm is located. 202,
Right.
we're not sure what that was.
Right.
It appears to be the City Eats Kitchen at 210. That's at 210 South Main, according to the arrest affidavit.
Okay.
And the State Farm building is 202.
Let's just be careful with it. I guess I'm more concerned about the restaurant, if that's where he may have been drinking. So that's at the 210, correct?
Correct.
All right. So let me order the stay away from the 210 South Main Street, the restaurant. Maybe a restaurant bar, so he doesn't go there.
According to the arrest affidavit, it is the City Kitchen Restaurant.
Okay. All right. Let's stay away from the City Kitchen Restaurant. Thank you.
Position number 12, please.
This is 22 CR 005564A, Larry Mitchell. You're charged with 1 count of simple battery, family violence, a 2nd count of criminal trespass, both with the offense date of May 21st, 2022. Pre-trial.
57 cycles. Last arrest August of this year for DUI in Coweta County. No disposition listed on that arrest. Record does indicate the defendant is on probation for forgery in the 1st degree. Case number 10 CR 00081, sentenced April of 2011, 3 years confinement, 10 years probation in Walton County, Georgia. Record indicates four violations of probation, 2 failure to appear within the past 10 years. 2020 misdemeanor battery, family violence, 2015 battery, family violence in Clayton County. A 2013 felony conviction for aggravated stalking. Nothing further to add.
All right. ASG, let's see which one. Okay, ASG Waldrop.
Yes, Judge. With respect to this particular case, just a little bit about the facts. This charge actually stems from an incident that occurred when the defendant and his wife, with whom he has been separated, got into an argument, at which time the defendant punched her in the face with a closed fist and then buried his fist in her neck. He then left the hotel room that they were at, and she closed the door and called 911. He broke the window of the room in order to get back in, at which time she fled into the parking lot, where he pursued her and chased her into the parking lot. Her fleeing that room, I think, gives you some indication of the level of fear that the victim was in at the time. Ultimately, he was arrested and charged. With respect to the state's recommendation on bond, the state is recommending on bond on the count of simple battery, a $5,000 straight bond, and on the count of criminal trespass that was added for the window that was broken, a $1,000 straight bond. And Your Honor, we are also recommending no further contact with Miss Jasmine Grayer. That is Jasmine, Jasmine, Grayer, Grayer. that he stay away from the incident location of 2788 Forest Hills Drive, have no drugs or alcohol while out on bond, and no weapons on or about his person. And Your Honor, the basis for that is not just the facts, the alleged facts of the case, but as you heard, the defendant has a prior ag stalking conviction as well as a 2016 battery conviction. He has multiple FTAs, an extensive criminal history of 57 cycles. That also includes probation violations. The state believes that that is a clear indication that the defendant will not only not return to court to face these charges, but that he clearly has issues following the law and judge's orders. And so that is what the state would be requesting, is a $5,000 straight bond on the simple battery and a $1,000 straight bond on the criminal trespass.
Ms. Waldrop, what was that address? Stay
That
away.
address is 2788 Forest, Forrest Hills Drive.
Oh, is that the Days Inn? The hotel?
Correct.
Okay. All right. Your Honor, I would ask the court to consider the facts stated in the affidavit for arrest that maybe it's questionable as to who started this fight. Both parties were drinking alcohol. They went to the hotel. Apparently that's either of them live there or have anything to do there. They just went there and started drinking, got into a dispute about one or both parties' infidelity. And then the argument and the dispute escalated from there. Stay away, though not necessarily related to the case. That's fine. There's no objection to it. We just asked for I believe the bond recommendation was a total of $6,000.
Correct.
Okay. Would ask the court to consider a lower bond. He is not currently on probation or no warrants at this time.
All right, I understand that the victim is online. I think I see a Jasmine. Is it Grayer? Miss Grayer,
Yes, I'm here.
would you like to address the court?
Yes.
Okay, if you do, you have to turn on your camera for me.
Okay.
All right, and I'm going to swear you in. Raise your right hand for me. Do you affirm that the testimony that you're about to give is the truth and nothing but the truth under the penalty of perjury?
Yes, I do.
All right, you put your hand down. Are you in fear of Mr. Larry Mitchell?
No, I'm not.
Okay, he was residing with you.
We were together that night. Yes.
Okay, does he reside with you at this Forest Hills address?
No.
Okay, is that your address?
And what's the address? The one where the incident happened?
Yes.
No, we were at a hotel.
Okay, so that Days Inn, I think I heard Mr. Silverman say, so that is not your living address. You were just there.
No, correct. That's
Okay.
not where we live.
Okay, but do you all reside together somewhere else?
At his mom, 2607 Rex Road.
So you reside there with him and his mother?
No, I stay there occasionally.
Anything else you would like to say to the court?
I'm not in fear of my husband, and he was not chasing me in a parking lot the night of the incident, and he did not punch me in the face. He slapped me. I mean, it was still a hit, but we got into an altercation, but he did not punch me.
All right, any cross-examination by ASG Waldrop or PD Silverman?
Not from the defendant.
Okay. Waldrop?
Your Honor, I will stand on what the state has requested. I think it is appropriate, not only given the facts that the victim reported to the officer, which the officer can only go on what is told to him. And he writes in his warrant that the victim indicated to him that she was punched with a closed fist in the face And then the defendant then took his closed fist and buried it in her neck. The officer, I don't believe, has any reason to lie or make up facts. And Your Honor, given the extensive criminal history that we heard read, the state would stand on what it has requested with regard to the surety bond and the various conditions of no further contact, stay away, no drugs or alcohol, no weapons.
All right.
I'm sorry, Matt.
Yeah.
The defendant is not suggesting at this point that the officer was lying. However, in the heat of the moment and in writing a lengthy report, it's certainly possible that the officer misconstrued what Ms. Grayer said. What's important is that what Ms. Grayer says, I think, really controls at this point. She's here. She's subject to examination by the state or questioning by the court. She says that she is not in fear of the defendant and that he did not punch her. He did slap her, which also is not appropriate, of course, but that doesn't really lessen it at all. But the situation was not as egregious as it sounds. And again, I asked the court to take in and give more credibility at this point to the weight of Ms. Grayer's statements. And that's all I have.
All right, I'm going to order the $6,000 surety bond. That's $5,000 on the simple battery, $1,000 on the criminal trespass. I'm going to order no further violent contact with Jasmine Grayer. And I don't have a good address on a stay away because she states that they don't reside together and she may stay occasionally at this Redbird address. No drugs, alcohol, or weapons while on bond. Is there anything else in your take up, counsel?
Your Honor, I was just going to state that he did break the window of this Days Inn, so I would imagine that they prefer that he not go back there, but I'll leave it up to the court.
Okay, I will order a stay away from the Days Inn at 2788 Hills, Forest Hills Drive. So stay away from the Days Inn. All right. Anything else?
Nothing further from the state judge.
And nothing further from the defendant.
Thank you.
Position number 15.
Okay. This is 22 CR 005558Y, Justin Owen, charged with 1 count of interference with custody. The offense date is August the 19th, 2022. Pretrial.
Second arrest. First arrest was August of this year for aggravated assault in Fulton County. That is an open case, 22 CP 211298. Nothing further to add.
All right. ASG Waldrop.
Thank you, Judge. With respect to this case, just a brief factual background. The victim, well, the victim's mother in the case, Miss Maureen Buñuelos Rivera, had had surgery recently. The defendant was at her residence looking after the child that they shared together when he took the child without her permission or consent, and stated that he was taking the child to his mother's house, his mother living in South Carolina. Miss Rivera was adamantly opposed to this and had to call 911 in order to get the defendant to bring the child back to the home. With respect to bond, Your Honor, and the state's recommendation, the state is recommending a bond of a $2,000 straight bond or surety bond that is based on the defendant's history. As you heard, he has an open aggravated assault case that is currently open in Superior Court. In addition to that, we are asking that the defendant have no drugs or alcohol while out on bond, no weapons on or about his person, and that any contact with the child be pursuant to supervised visitation. And that minor child's name is Justin Alexander Owens. This is an 8-month-old child, Judge.
All right. Mr. McLean?
Yes, Your Honor. Mr. Owens is a 25-year-old person with 3 years of college in marketing. He is maintaining his innocence on that ag assault case that is open. He's kind of tapped out financially right now. It's a $10,000 bond. He does work with Ox and Bull Moving Company. That is his only other arrest. A good mailing address would be his mother's address in Blythewood. I think I'm pronouncing it right. Blythewood, South Carolina is at 152 Hunters Run Drive. Your Honor, we discussed this case. This is a very foolish thing that misjudgment, but his intentions were sincere in trying to take care of the child because he really felt like with the surgery that she could not at the time, but she really doesn't like his mom. That causes some tension, probably accounts for some of the attitude that was described in the police report about words had with everybody. So it was an unfortunate police report in terms of vulgar things said. However, when it's all said and done, this was not harmful, no harm ever intended, but a foolish mistake.
Your Honor, Justin Alexander Owens is my name. His name is Josepha. And this may not be noticed, but I complied with everything and was in the process of bringing him back. I even talked to the detective 30 minutes before, and I told him I would come back soon. I was changing him. I had a lot of emotion filled because I just couldn't bring my baby to see my mom, which is ridiculous. But like I said, it wasn't a good judgment, but I take accountability for what happened, and just any chance to be a little bond. Thank you, Your Honor.
All right. And what was the state's recommendation again, Ms. Wilder?
Your Honor, it was a $2,000 surety bond.
Okay.
And of course, we would, as normal, we would ask to have the court consider a signature bond. He already has made a $10,000 bond on that thing where another gentleman, he were said to have been in a altercation, and he was accused of hitting the other person with a flashlight.
Okay. All right, I'm going to order the $2,000 surety bond. I'm going to order no drugs, alcohol, or weapons while on bond. I'm going to order if there is any visitation with the child, that be supervised by a third party. And what was the name of the victim for no further contact? Or did
Miss, the child's mother or the child?
the child's mother?
Mirain, that's M-I-R-A-I-N.
Yeah.
I think it's pronounced Miriam, probably.
Okay.
Right.
All right.
My apologies. Buenuelos Rivera. That is BENUELOS -RIVERA.
All right, I'm going to order stay away from her if there's visitation with a child, that be done by third party supervised. And they stay away from 152, is that Hunter's Road?
No, that's his good mailing address at his mother's address in South Carolina. The
so what
the
was
other
the
place to
incident?
stay away from would be the state would have that.
Yes, Judge, I have 875 Roswell Creek Lane.
Okay. And then a stay away from 875 Roswell Creek Lane. Sorry about that.
And I think Banuelos is BA.
Oh, on her last name?
Right.
Instead of V as in Victor's, B as in boy.
Well, a BA instead of BE, because I think we've got a very poor copy.
Yes.
So the print is so tiny, we could barely read the vowels.
Oh, okay.
Yes, Your Honor, it's not clear on the warrant, but it may be BA.
Ms. Grace, are you clear as to what the spelling is to put into the bond order?
I have BANUELOS for the last name.
It's probably E. It's probably ES. Well, it may be an O. You're probably right. It's probably an OS.
Mr. Owens, do you know how to spell the victim mother's last name?
Yeah.
Can you spell it, please?
BONUELOS.
So it's not even as written. The correct thing should have been BO or what?
Yeah.
Okay.
And the first name, please.
Miriam.
Spell that.
MIRIA.
M-
MIRIAN.
Okay.
Your Honor, would it give context that she was unable to take care of him because she just simply had surgery? So I decided to take him to my mom's for the weekend because she needs to rest and recover.
Yeah, we did cover that, Mr. Owens.
Making sure she was asleep. I don't know.
Yeah, but I'm concerned a little bit. Making sure there's been ample cooling down period. And that everyone's going to be safe. All right, that's the ruling of the court.
Position 18.
Judge,
Yeah.
sorry, Judge, did you do a no further contact?
Yes, I did.
Thank you.
All right, this is 1822 CR 0055556A. Jerome Rivers, you're charged with 1 count of driving while license suspended or revoked. Offense date is 8/19/2022. Pretrial.
10 cycles, last arrest December of 2021 for DUI under the influence, driving while license suspended or revoked, endangering a child by driving under the influence of alcohol or drug in Spalding County, Georgia. No disposition listed on that arrest. Record does indicate a 2013 and 2011 DUI misdemeanor conviction and driving without valid license. I'm sorry, driving while license suspended 2002 in 2013 and 1 in 2011 misdemeanor convictions. 2 violations of probation within the past 10 years. Nothing further.
Okay. All right, ASG Waldrop.
Yes, Judge. This just stems from a traffic stop. The officer noticed a tag that was expired, and upon making contact with the driver, the defendant ran his license, saw that it was suspended due to child support, Your Honor. This is a second in 5 years for this offense. As you heard, he previously got a driving without a valid license charge in December of 2021. State's recommendation is a $1,500 straight bond. And with regard to conditions, we would ask that the defendant not drive without a valid license. And so not drive unless or until his license is valid.
All right.
Your Honor, he's completely in agreement with not driving without a valid license. He says he's got to simply get to work by other means and understands what the law is. He isn't, his education includes graduating from Atlanta's Cordon Bleu. He is a manager at a restaurant called the Albert. His address is stable and has been since 2005. His employment is stable. He has been a manager at various restaurants since 2011. And we would ask the court for those reasons to consider a signature bond, that he realizes that his traffic offenses have to be accounted for.
All right, I'm going to order the $1,500 signature bond through the jail. I'm going to order there be no drugs, alcohol, or weapons while on bond. And if you are driving, which you probably shouldn't, you must have a valid driver's license through DDS. If you don't, you cannot drive. And as your attorney says, seek ride shares and other things, a cab or whatever for getting around. Because if you don't have a license, you should not be driving. All right, 1,500 SOB through the jail.
Thank you.
I have position number 19.
Okay. This is 22 CR 005555F. Johnny Youngblood, you charge at 1 count of battery, substantial physical harm. The offense date is July 28th, 2021. Pretrial.
31 cycles, last arrest December of 2020 for theft by conversion in DeKalb County. That is an open case, 2G2389, one failure to appear within the past 10 years. I have a 1998 battery, simple battery family violence conviction. Nothing further.
All right. Alger.
Yes, Judge. Just a brief factual basis. This particular charge stems from an incident that occurred between the defendant and Miss Elizabeth Klinkskills. They are in the process of going through a divorce. They got into an argument during which time the defendant slapped the victim and placed his hand on her neck, then forcefully pushing her or throwing her to the ground. This occurred at their home at 710 Casplin Street and was witnessed by the children who gave an account to the police of the incident between their parents. With respect to bond, the state's recommendation is a $5,000 straight bond. We would be asking no further contact with Elizabeth Klinkskills, that he stay away from the incident location of 710 Casplin, that's Casplan Street, have no drugs or alcohol while out on bond, no weapons on or about his person. As you heard, there's at least one FTA within the last 10 years. I think that gives an indication of his propensity to not appear for court. As well, you heard that there was prior convictions for simple battery and battery. And so that would be the request from the state with regard to bond.
All right, Mr. McLean.
Was Ms. Klinkskills on Zoom or not? I don't see an indication.
No, Ms. Klinkskills or anyone with the Youngblood case.
I thought she was joined us, but Your Honor, he is 12 years at the same home address. His home address is actually 1371 Kimberly Way, Southwest, apartment 9204. He's 54 years old, and he tells me he's been at that address, and he says they are not at Kaplan. And I did confirm his employment with his employer. It's an HTH company cleaning service, and it's Mr. Earl Harris, and he did say yes, he's worked with me for the last 8 years. I didn't even, because that's just checking on the employment, and it's stable employment. I didn't bother to ask him. I didn't ask him to come join us on Zoom because it's not the case itself. It's just confirming a fact about him. So he is stable and he denies the facts. And we had thought that Ms. Clinkscales was going to be on to deny them as well, but she is not. So we would ask the court nonetheless to consider as low a bond as possible. Signature if possible. It is one count, and it is an allegation of a small bruise on the left side of the face.
Your Honor, may I add?
Also, I might note that it is from the summer of 2021, not the summer of 2022. Mr. Youngblood, I've said enough for you, so we would ask you to be quiet, please. Thank you.
All right, so the incident location was on Kaplan Street.
Casplan, Casplan.
But Mr. Youngblood does not reside there. Is that correct?
That's what he says, 1371 Kimberly.
Okay.
How far away from Casplan is that?
1371 Kimberly is all the way on Cascade, the 285 side of Cascade.
Is that where Ms. Clinkscale resides at Kaplan?
The Kaplan is over by Atlanta Area Tech College.
Okay.
1371 Kimberly Way where I stay is off the 285 exit of Cascade.
Okay.
And
all right.
ma'am, I'm sorry. One more thing on that failure to appeal. The reason why
that's not your Mr. Youngblood. The judge has the facts and the allegations with which to make a decision.
I apologize, Your Honor.
It's okay.
No problem. I am going to order a $4,000 surety bond. I'm going to order no further contact with Elizabeth Clinkscales. I'm going to order no drugs, alcohol, or weapons while on bond. And I'm going to order stay away from the incident location. And give us that address again. Ms. Waldrop, I apologize.
No problem, Judge. It is 710 Casplan, Casplan Street.
And stay away from that address, Mr. Youngblood, but a $4,000 surety bond is the ruling of the court, and no further contact with Ms. Clinkscales. All right.
Yes, ma'am.
All right, that should be the ruling of the court. Is that all we have, Deputy?
That's all I have, Judge.
Okay, have a good weekend.
Thank you.
Whenever you're ready, Ms. Grace.
Your Honor, if I can, just quick note on, I think it was position number 10, Mr. Harrison. I did try to go back in and NOD that cruelty to children in the third charge. It will not allow me to do it. I think what happened was I filed it down to state instead of not on docket by accident. So I apologize for that. So if the clerk's office could either let me know what I need to do or open that back up so that I can file it down to the appropriate place, I'll do that.
Okay. Ms. Grace, who's my Zoom coordinator for today? Is it Mr. Jordan?
Hi, Judge. It's Miss Champion today.
Oh, Miss Champion, do you know how to do that, or should she just send me an NOD form?
She can send you a NALPROS form.
I mean, a NALPROS. I'm sorry, yes. You want to just send me a NALPROS form, ASG Waldrop?
Yes, I can do that. Should I send it to the clerk's office email or your email or?
You can email it to melissa.grace.
Okay.
Yeah, at fultoncountyga.gov, and then she'll send it over with the other orders.
Okay.
Okay. You there, Miss Grace?
Yes, ma'am, I'm ready.
Okay.
Okay, position number 1 is a $1,500 good bond. Position number 2 is a $2,000 good bond. Position number 3 is a $5,000 good bond. Position number 4 is reset to the 8/22 SEA calendar. Position number 5 is a $3,500 good pretrial bond. Position number 6 is a $4,000 pretrial bond. Position number 7 is a $1,500 good bond. Position number 8 is a $4,000 pretrial bond. Position number 9 is a $1,500 SOB through the jail. Position number 10 is a $5,000 good bond. Position 11 is a $3,000 good bond. Position number 12 is a $6,000 good bond. Position number 13 is a $3,000 good bond. Position number 14 is a $2,000 pretrial bond. Position number 15 is a $2,000 good bond. Position number 16 is a $2,000 pretrial bond. Position number 17 is a $4,000 pretrial bond. Position number 18 is a $1,500 sign-on bond through the jail. Position number 19 is a $4,000 good bond. Any questions?
Ma'am, that's what I have. Anyone else have any questions or conflicts at all? Nope. All right, I will let you all go and enjoy the rest of your Saturday.
Thank you.
All right.
Please,
take care.
ASG Wardrobe, send over that non-pros order as soon as possible.
Yes, ma'am.
Thank
All
you.
right. Thank you. Take care.
Thank
everybody.
you. Have a good weekend.
You too. All
Bye.
right.
Good to see
Bye-bye.
you, Judge.
You too.
Bye.
Bye-bye.